Thank you very much, Mr President, and thank you for the invitation to be here. My name is Boucher. I occupy the position of Commissioner for Uniform Legal Services Regulation, and as such I'm also the CEO of the Legal Services Council. As I'll explain in a minute later, I would prefer to be seen as being here as the Commissioner rather than representing the Council so much today. My background is I've been admitted since 1971. I had 28 years in the Commonwealth Attorney General's Department as a prosecutor, commercial lawyer, policy lawyer, legal manager. 16 years in the SES. I became the Australian Government Solicitor and then the first CEO of AGS and commercialised that organisation as required by two governments. I had a short period as a member of the Australian Communications Authority to do a one-off task, and then I enjoyed working with you, Mr President, as a partner at Mr Allison, where I was for 3 years and a further year as General Counsel. I conducted my own legal management and consulting business for 6 years between 2003 and 2009. And in 2009, I was appointed to be the inaugural chairman of the Tax Practitioners Board and established that as a national body for a bit over 3 years. In 2013-14, I resumed my business, did a bit of consulting and other work. And in September 2014, I was appointed for 1 year to be the inaugural commissioner. I've since been appointed for a further 2 years until September next year. So, turning to remarks about the terms of reference, before I begin, I'd like to congratulate the Law Society on this initiative. You certainly have very broad terms of reference, and I'm pleased you've asked me only to address a limited number of questions. As I make clear, I'm appearing as the Commissioner rather than CEO. The Council might itself want in time, if you wish, to address some of the issues in your questions, and I'm sure that the Council will in particular consider any report from this committee with keen interest. To give my remarks this morning some context, I do want to make, I don't think you'll be surprised by this, but some remarks about the uniform law, because I would recommend to the Law Society of New South Wales, as you have done in the past, you continue to be a leader in this field, and particularly in the way that you supported this council when it was established in 2014 and facilitated it getting up. I think there is a need for leadership in Australia to ensure that good measures like the uniform law are adopted. And just a few features of the uniform law. Under the uniform law, and this is for the record of your Commission, if I may, local autonomy remains, so the jurisdiction of the Supreme Courts is unchanged. It's enacted as a state statute and local regulatory bodies continue unchanged. State application acts provide for local machinery arrangements. So there's a common framework next that applies to regulation of the legal profession in each jurisdiction. There is a light touch overarching structure with the Council operating and the Commissioner. We think in the Legal Services Council that the cost for legal practitioners Australia-wide to have a national body like the Legal Services Council would be about $20 to $30 per annum per practitioner. Our budget currently is quite low. It would need to increase slightly, but not much. There is a collaborative approach being taken to the operation of the uniform law, and certainly happened in its implementation. There are inbuilt consultation requirements, and there are benefits, we think, being realised both for governments, for the profession, law firms and consumers. In particular, a single policy process has been created. The Council is becoming an expert advisory body to governments, and law practices, we think, are benefiting from the common framework in which it operates, and particular consumers benefit and may benefit more in future. I should also place on record, Mr Chairman, that there are, as we all know, only 2 Australian jurisdictions that have adopted the uniform law. I'm pleased to say that most, if not others, not all others, have kept it under appraisal, and a number appear to be favourably disposed. But as I'll indicate later, I feel that the profession needs to have a united front to face the issues you raise in your terms of reference, or if not, some other way to find better solutions in future. And as I say, we don't think cost is an issue. I also should place on record that the council was able, with the full cooperation of all parties, to make the rules and do the necessary work to enable the Uniform Law to start on the 1st of July in a very short time frame. We're now nearly 18 months since that commenced, and a body of rules has only need to have minor change and the Act a few changes. So I say that not to seek any plaudits, but really to demonstrate and to provide evidence that the exercise was able to be undertaken, we're able to work together and get results, and it could happen again if others join in. Further and finally, national admission for practitioners has been in place for some time, and perhaps the thought could be that adopted that as a corollary there should be a national legal profession. If we have national admission, why don't we have the same law, particularly having regard, for example, to the comments that Mr Mackenzie made a little earlier. So they are my introductory comments.
Thank you. You will have heard from both the New South Wales Legal Services Commissioner and the Law Society's Director for Professional Standards, their views about whether there's a need for regulation to be anticipating change or to simply be catching up. What is your view about that? Look,
I've heard the information provided this morning by both Ms Ford and Mr Mackenzie, and I must say I didn't, with respect, disagree with anything that they said. But I do have a number of other remarks about this. So we all recognise that the economy is in a transition and we're living in a period of rapid change. And I think we all accept there are no magic bullets. But I do think that the Uniform Law framework offers the best solution and possibility for change in the issues implied in the question. So let me try to explain. It provides that legal services can be provided under any business structure subject to the law and the rules. And further, practitioners must comply with the law and rules regardless of the business structure in which they operate. So we can and may well in future recognise new business structures. I can't go into the details, but I note in passing that we've recently been asked to consider another model and are seeking details about that. But the point has to be made up front that the Uniform Law at present only operates in the two states, and even if it covers 70% of the profession. It's also true that the Legal Profession Acts in the other states are not radically different, but they're not the same. And they don't have the same collaborative and effective overarching governance structure in which the profession now in the two states has a considerable stake. I'll say a bit more about that shortly, but before I do, I'd like to also, if I may, add some perspective about some of the challenges. And of course, many of these you'll be aware, but if I may offer these. Innovation in the production and delivery of legal services, there are some examples in your terms of reference, but use of artificial intelligence to perform repeat tasks, offshore document processing and production, lawyers contracting out or contracting in via label websites or off-the-shelf documents being used. And legal services, as again Mr Mackenzie said, can be easily delivered across state and national borders, just as may have happened for ages, but more so now perhaps. We're living in an information economy where information and knowledge is rapidly copied and shared at minimal or no cost. Communication technology is with us all the time, and people expect to access goods and services at little or no cost. That has implications for the value proposition for lawyers and for clients. They ask what's the value added for a local solicitor and how does the profession itself maintain high standards and adapt? How are consumers protected and how can they benefit? At least three of the challenges here are, so how do we keep up? What are our sources of information? How do we adjust the law and when? It's important to be able to respond to change but also see opportunities. New technologies will not remove the need for value or the value of regulatory schemes to provide an assurance of competent professional standards and which may perhaps be utilitarian. Nor will new technologies remove the basic need for people or organisations to access professional advice about their specific relations with each other. You know, the prenuptial agreement example that you might get from another country would lead perhaps to questions of how's that going to suit your circumstances and the requirements of Australian law. Now, another point is, and it's a challenge, are we missing opportunities? A subset of seeing opportunities and difficulties in change is to ask whether we can be trapped in our own paradigms. I'm thinking here of the complaints that have been made about cost disclosure in some places. Large firms have no trouble with disclosing costs to clients and keeping them up to date. But are those law practices see problems and with keeping consumers up to date, and there have been some, are they missing the opportunity that disclosure presents for engagement with their clients? Are some of us so concerned about the legitimate desire of consumers to be kept informed that we miss the chance which this provides? Could mindsets do with a refresh on the point? So a further challenge is to communicate with consumers so that they're aware of the risks about the solutions coming from new technologies and to take advantage of them. Regulation perhaps could assist to mandate some level of communication with consumers on all occasions. I think we need to be particularly careful to ensure that professional values and standards are maintained. Of course, we must adapt to change, and it's our duty as lawyers to do so. But some principles must remain constant. Indeed, they must guide our responses to change. The essence of the principles that guide us entitle us to call us a profession, but we're not just a licensed occupation, and that doesn't change. The legal profession is concerned with justice as well as law, with access as well as excellence, and with service to the community. We should see ourselves as disinterested professionals who act in the best interests of our clients and apply human judgment as well as using the best technology available. And if we do so, how could any online service easily compete with that? Along the same lines, it would be, what a great thing it would be for consumers if Australia-wide there could be a common understanding of what to expect when you use an Australian lawyer. That could come about if current work that we're doing on how best cost disclosure could be done can be brought to a suitable conclusion, and if later all jurisdictions were to adopt the uniform law. But again, what a great thing it would be if there was a common understanding, and what a great benefit for the profession that there would be. And finally, there is that delicious problem of the meaning of the extent of the phrase engage in legal practice, and how do we regulate across borders? A subset of this is what is our state of readiness if ever there were need to coordinate a national response to any regulatory issue. At present, we would be working from 7 similar but different texts and regulatory systems with no formal overarching structure. And invitations to talk about the issue by telephone if you're lucky. So while we have these challenges, we have in the uniform law a fundamental architecture that's flexible, it can facilitate change and meet the challenges that emerge while still serving the broad attention of liberalising the regulatory framework. And the Council's been created to do that. And so they're probably the main points I'd like to make about that, apart from us again stressing that I believe the uniform law is working well. It's showing excellent results from collaboration. We've built a database with the help of the society, which is being enhanced with the leadership of the society, and it's a prime example which we hope to be able to display next year. There are many others that I could give, so thank you
for that. With the changes that are taking place within the legal profession, are there any that keep you awake at night?
There are lots of things that kept me awake at night, but I think I would say that we think that the architecture is there, and we rely particularly very strongly on our partnerships with the profession and also with the other regulators and with the commissioners and with the Law Council as a major partner to work on these things together. So I have confidence that we have a framework that can address questions.
And a framework that can meet the changes that are taking place within the profession, or those that we don't yet know about?
Well, look, I don't pretend to say that we have answers to the questions that we don't yet know about, but I think we have a way of working, a framework and architecture, call it what you will, where we have an established record of being able to nut out problems and come to solutions. But the fundamental and basic point is we have to be singing from the same song sheet. And it's just so difficult if we're not. So,
can I just change the subject slightly, and that is the way we treat foreign lawyers,
Yeah.
certainly in New South Wales, but also more broadly in Australia. With the increased number of law graduates coming out of university, do you see that the increase in the number of foreign lawyers coming into this country is an issue that is firstly being adequately dealt with in terms of their admission requirements, but also secondly, is there something that could be done to either facilitate their entry into Australia or not?
Well, look, just to get a simple thing out of the way first, the uniform law has only been amended in the last, I think 6 November it was notified in Victoria, to again permit partnerships of foreign lawyers in Australia. I know that the admissions committee with which we work closely, and the council observes their work, it's largely an independent body, but we observe and support their work, have been working on guidelines in relation to sections 18 and 20, and that's a work in progress. I would not be a doomsayer or an alarmist about foreign lawyers coming in. I mean, I think that the fundamental rules that we have about our admission standards are basically correct, and they've been enduring for some time, and they provide a suitable answer. But again, there could be issues or problems that we need to look at. But we have to stick to our standards and professionalism, and I think also, look, it's not something that I've looked into in great detail at all, but bear in mind the principle of comity in relation to Australian lawyers going overseas.
Can I just go back to, ask you this. You obviously work with the other regulators around Australia. Do they anticipate any major trends that are looming over the horizon, or are we at a stage now where we're just dealing with sort of different types of issues that keep cropping up, and we'll deal with them as they do crop up? For example, the way in which organisations like Uber and Airbnb came into the market in a way which wasn't, they weren't properly, or they weren't regulated at all, and the law caught up with them. Do you anticipate any changes like that coming in so far as the legal profession is concerned?
Well, I'm going to be brave and courageous here. We do and we do not work with the other regulators. I see them, and in fact I had the pleasure of seeing most or all of them only 2 or 3 weeks ago at the annual conference of regulatory officers, and there's a monthly hookup. We also, at the Legal Services Council, and me particularly, we travel the country a little bit talking to them. But on the other hand, the truthful answer is I don't work with them all that much. I work much more with the commissioners in Victoria and New South Wales, and I hope it could be said I work frequently with them, and we see each other often. In fact, we're having another meeting next week. I rely particularly on them, and I think they deal much more with the regulators in other states. But, you know, there is this, it's not a divide, because I think we all know each other and we get on well, and everyone's professional and the issues are pretty much the same, but that's the point. You know, there is no overarching structure that enables us regularly and frequently to talk to other regulators in the other states about those problems that are in your question. You know, we might hear about it if we're lucky, might hear it on a phone call, but then on a phone call, which is sort of for half an hour or 20 minutes, are people going to open up and really talk about the problems? Perhaps not.
Yep. Understand.
So there's a big problem.
Yep.
Just in having a united approach. I mean, the legal profession in New South Wales, dare I say with respect, is not going to be able to solve all these problems unless we have the Victorians in, as we do, and also unless really we address that position and problem about the borders. I mean, look, let's get over ourselves. We should have a single national legal profession framework.
It's a legacy of federation, perhaps.
Well, perhaps.